Hello everyone and welcome back to Legal Notes. Hope you all are doing great. So here's the video on Bar Council of India and second video in the series of Advocates Act 1961 or the subject legal ethics. So starting with the video, section 4(1) tells in the Advocates Act 1961 provides about the necessity of Bar Council of India and the members that shall constitute Bar Council of India. So it says members should be first Attorney General of India, ex officio Attorney General, second is ex officio Solicitor General of India, and third one member elected by each state bar council from amongst its members. So every state selects a member amongst its members and that member represents his state in the Bar Council of India. Now in section 4(2), it says that Bar Council of India shall also constitute of chairman and a vice chairman who are to be elected in a manner as may be prescribed in the Advocates Act. Now in section 4(3), it gives provision about the term of office of the members elected from the state bar councils. So for first, if an ex officio member from the state bar council is elected, then his term will be 2 years from the date of his election or till he ceases to be the member of state bar council, whichever is earlier. Second is any other case apart from the ex officio case, if any member is elected by the state bar council to represent the state in the Bar Council of India, then that member shall be appointed in as for the term for period for which he holds office as a member of state bar council. As long he remains in the state bar council, he will represent his state in the Bar Council of India. Now is for the admission as advocates or for the admission of advocates. This is one of the functions of Bar Council of India. So about the admission of advocates, section 18, section 19 and section 20, these three sections deal with this topic. Section 18 says transfer of name from one state role to another. If any advocate or lawyer or legal practitioner wants his name to be transferred from one state to another, then that member shall write an application to the Bar Council of India in a prescribed form, and on receival of that application, Bar Council of India will direct the state to transfer the name of that applicant, and this procedure will be conducted without any fee. Now is section 19. Every state bar council shall send to BCI authenticated copy. Every bar council, every state bar council is required to send the records, copy of the records for first roll of advocates prepared for the first time. If any advocate or every year as new advocates are enrolled in the state bar council, the copy of that list, the copy of that account shall be sent to the Bar Council of India. Second, any alternations made in the rolls. So alternations means whenever an advocate is transferred from that state to another or any other member is enrolled in that state bar council, those alternations are also to be reported to the Bar Council of India. Now comes section 20. Every advocate who was entitled a right to practice in the Supreme Court of India and whose name is not entered in any state roll shall apply to the Bar Council of India within prescribed time and within prescribed format to be enrolled in any state bar council which he wants to be enrolled in. But if he omits or fails to do so in the prescribed time, then that member will automatically be enrolled in the State Bar Council of Delhi. and this procedure will also occur without any fee. Now is appointment of committee and state and staff members. So for this, section 9 provides for the appointment of disciplinary committee. Disciplinary Committee of Bar Council of India. Disciplinary committee can be one or more, and it shall constitute of 3 persons, out of which 2 must be amongst its members, and 1 will be the person co-opted by the council from amongst the advocates. Any advocates which the bar council thinks is deserving candidate, and that advocate shall not be the member of the bar council. And among those 3 persons, whichever is the senior most member, he will become the chairman of the disciplinary committee. Now section 9A tells about the appointment of legal aid committee, that shall constitute of more than 5 members but less than 9 members. Section 10(1) tells about appointment of standing committee. Section 10(2) tells about executive committee as well as legal education committee. So executive committee shall constitute of 9 members, and all those members will be amongst the members of Bar Council of India. And legal education committee shall constitute of 10 members, out of which 5 must be amongst its members, and the remaining 5 will be co-opted by the council, and those co-opted members must not be amongst the members of Bar Council of India. Now is section 11. Section 11 tells about the appointment of a secretary and appointment of an accountant or any other member as may deem necessary by the Bar Council of India. For maintenance of accounts, section 12 tells that Bar Council of India shall maintain account book in a prescribed format, and that account book shall be audited by a duly qualified auditor, and the qualification for the auditor are or will be the same as given in the Companies Act 1956. Section 15 is the rule making power. Section 15 provides the rule making power to the Bar Council of India. Section 7A and Section 7(2) deals with the funds and contributions made by the Bar Council of India. Section 7 in whole tells about the functions of Bar Council of India. The functions like to manage and invest the funds, to provide for elections, and to organize legal aid to the poor, and to promote and support law reforms, to lay down standards of professional conduct and etiquettes, to lay down procedure to be followed by the disciplinary committee and the disciplinary committee of State Bar Council, to recognize universities for legal education, to promote legal education, and to conduct seminar and organize talks on legal topics. All these are the functions of Bar Council of India. Now section 14, it says that no election of a member to a bar council or any committee shall be called in question on the ground merely that due notice thereof has not been given to any person entitled to vote, thereof been published in official gazette. If about any elections or about selection of a member for a bar council or any committee has been published in the official gazette, and after that a member has been selected for the bar council or any committee, then no other voter can question his selection just on the basis that he wasn't given prior notice for the elections or for the selection. So this was all for today's video. Hope you all liked it, and if you do, please turn that thumbs up, and also comment down below and tell me how do you like the video. Share with your friends and spread the knowledge. Have a good day. Bye bye.